Record, we oppose the application. And Your Lordship, we have filed the following documents: a notice of preliminary objection dated 15th of May. Your Lordship, challenging the jurisdiction of the court. We have also filed a replying affidavit sworn by one Mr. Jeremiah Ndombi on the 15th of May 2025. Your Lordship will be relying on those documents. And I also associate myself, Your Lordship, with the submissions made by my learned friends for the first and second respondents. Your Lordship, I'll address three key issues briefly. And the first issue, Your Lordship, that I wish to address you on is the application is justiciable at this stage. Your Lordship, I will also address you on whether the applicants before you have exhausted all the available avenues for grant of conservatory orders. Issue, Your Lordship, whether the application is justiciable. Your Lordship, the process of appointing commissioners to constitutional commissions Article 252, Your Lordship, sequential process for appointment of commissioners. That is, in this case, Your Lordship, it has already been done by the selection panel. And the last step, Your Lordship, is the selection panel has already exercised discharged its mandates. And on the 8th of May 2025, Your Lordship, the Excellency, the President forwarded the nominees for appointment to the Iebc to the National Assembly for vetting and approval. The vetting and approval, Your Lordship, process has already started in the National Assembly. On the 12th of May, Your Lordship, the National Assembly invited members of the public to submit comments on the nominees to the voting committee, which is the Justice and Legal Affairs Committee. Therefore, Your Lordship, as of now, no decision has been made by either the committee or the House the process is still ongoing, Your Lordship. In fact, Your Lordship, the window for collecting public views is still open. Lordship, the Justice and Legal Affairs Committee is required to vet the nominees and present a report to the House. Or may not approve the nominees, Your Lordship. And therefore, Your Lordship, what this court is being asked to do at the moment, it's being invited to act on anticipated or feared outcomes that may or may not happen. It's our submission, Your Lordship, therefore, that the application before you, and indeed the petition itself, are premature and are not ripe for determination by this honorable court. On the second issue, Your Lordship, on whether the applicants have exhausted all the available avenues, it's our submission, Your Lordship, that the applicant have not. Article 118 of the Constitution, Your Lordship, and Section 6 of the Public Appointments Parliamentary Approval Acts the vetting process by the National Assembly is open to public participation. These provisions, Your Lordship, empower any member of the public including the applicants to submit views or raise objections before the vetting committee. For consideration before the final decision is made by the committee. Allow me, my Lord, to draw your attention to Section 7 of the Public Appointment Parliamentary Approval Act. That section, Your Lordship, specifically outlines matters to be considered by the National Assembly. The committee will also consider compliance with the constitutional and statutory requirements relating to the office and the overall suitability of the nominee to hold that office. Your Lordship, it's evident that the concerns raised by the applicants in the application, the mandate of the committee. The committee, Your Lordship, is fully empowered to investigate the nomination process, including all the issues as raised by the applicants. 3 minutes, I conclude. Yes, 3 minutes. Your kind permission. Thank you. Your Lordship, and this is lastly, Your Lordship, it's a summation that the application does not meet the threshold for grant of conservatory orders as prayed. For the following reasons, Your Lordship. One, The issues raised in the applications, Your Lordship, are issues that can only be determined upon full hearing of the petition on merits. Secondly, Your Lordship, the grant of the orders, conservatory orders are spread. At this stage, we'll have a constitutional mandated process with timelines. The committee is supposed to report to the House within 28 days. Otherwise, the nominations will be deemed to be approved formally under Section 9 of the Acts. Will be deemed to have been approved. If the committee will not have reported within 28 days, Your Lordship, the nominations will be the nominations will be deemed to have been approved. If they don't, the nominees that were presented to the committee and therefore, Your Lordship, is a process that has timelines. And lastly, Your Lordship, is the issue of public interest. Your Lordship, our submission is that it's in public interest that the process is allowed to continue. It's in public knowledge, Your Lordship, that since 2023 the Iebc has not been functioning. As a result, a number of constitutional functions are also stalled.
As my learned colleague, Mr. Bitter, pointed out, a conservatory order cannot issue unless there is alleged violation of fundamental rights. My Lord, a distinction must be drawn between violation of the Constitution and violation of fundamental rights. In this case, Lord, there is no allegation of any violation of fundamental rights. So under 23, the Constitution, an application for conservatory orders cannot be entertained. And Lord, that is a matter that can only be determined by looking at the petition and the application. My Lord, number 2, there are conditions that must be met before a conservatory order can issue. And Lord, those conditions were spelled out in the case of Gatigao Munya versus Dixon Mwenda Kisinji and others, which is case number 2 on our digest. And the first one is that there must be a prima facie case demonstrated. Number 2, it must be shown that if the orders are not issued, then substantial harm of a constitutional nature would result. Then 3, that if the orders sought are not granted, then the petition would be rendered nugatory. My Lord, allow me to point out and demonstrate that none of these 3 conditions have been met in this case. First, there is no prima facie case, my Lord. What has happened so far is that a list of nominated persons have been submitted to Parliament. And a distinction must be drawn, my Lord, between nomination of a candidate and appointment of a candidate. Nomination is just an expression of a preference for certain individuals. It does not constitute an appointment that would otherwise be challengeable before this honorable court. My friend, Mr. Odinga, relied on the Supreme Court decision in support of an argument that whenever there is a threat, then the court's jurisdiction is affirmed. Lord, it is my submission that that decision is being interpreted out of context. The nature of the threat must be considered. And the only threat that the Supreme Court would be talking about is a threat that has direct nexus with alleged violation of the Constitution, which is not the case here. To say that you have jurisdiction to intervene at this stage would be tantamount to say that you can also intervene to stop someone from applying for a position because his appointment was a violation. It will not be tantamount to saying that this court should stop the selection panel from considering a particular applicant from being considered for a position. It's the same thing now because we are still far off. Parliament is yet to consider the names. Parliament may reject the names. And even if Parliament approves the names, there's no guarantee that the President will just approve. So we are still far off, and so there is no direct threat. Which basically means, my Lord, that no prima facie case has been demonstrated. Number two, there is no harm that can be said to be capable of constituting a constitutional violation. A mere nomination of a candidate cannot constitute a constitutional harm. My Lord, it should also be appreciated that even if that was harm, it is not the kind of harm which, if not stopped through a conservatory order, then the petition will be rendered nugatory. My Lord, this process is still ongoing. The same way they have moved to challenge the nomination, they can still move to this court to challenge the appointment once it is done. So the element of nugatoriness does not exist and is not capable of being satisfied. And would allow me to rely on the decision in the case of Adrian Kamoto Njenga versus the selection panel for the appointment of commissioners of the Iebc. Lord, this is authority number one on our list of authorities. My Lord, the issues were exactly the same. The court took the position that the application for conservatory order made at the point of approval of the names by Parliament was premature. And we urge your Lordship also to find as much. My Lord, as concerns the first interested party, Adrian Kamoto Njenga was the selection panel for the appointment of commissioners of the Independent Electoral and Boundaries Commission 2021 EGELA. But as concerns the first interested party, the person proposed for the position of chair of Iebc, the only complaint raised against him is that he is a friend of one Josephat Nanok, who is alleged to be a friend of the president simply because he works as a presidential advisor. My Lord, this particular allegation is outrageous. It's based on assumptions that are illogical. To assume that a person is a friend of another simply because they have worked in the same institution is illogical. The mere fact that I work in the judiciary does not mean that everybody who works in the judiciary is my friend. Similarly, my lord, it is preposterous to assume that if someone is my friend, then all his friends are also my friend. Because that is the assumption that is being made here. And it is preposterous, my lord. But it's important also to point out, my lord, that a constitutional petition of this nature ought not to be grounded on assumptions. Evidence must be presented to show the basis of that claim to friendship, which has not been done here. And the upshot of all this, my lord, is that this particular petition, at least as far as the first respondent is concerned, has absolutely no merit. And my lord, it has been held by the Court of Appeal in the case of